And hello, hopefully everyone can hear me. My name is David Keston. I gave a webinar on the differences between the US and EPO practice a fortnight ago, and I am now returning to give part 2 of that same webinar, the material being spread between the two, with a rough division being that what I talked about in my part 1 was the day-to-day procedures, how one moves from essentially application to potentially grant. Whereas today I'm going to take you one step beyond and talk about some of the other differences between the US and EPO practice. Now, European law and procedures and culture are very different, and I wanted to emphasize this through the medium of cartoon. My cartoon character here is only there for the select few of us who are as ancient as I am. Rather than emphasize US style my achievements, I will emphasize my age, and the reason that I'm talking on this subject is that I am 20 years experienced as a patent attorney in the European realm, with some lengthy work with fellow associates who work in the US and the USPTO. Now, I wanted to emphasize why we need to discuss these differences, and really where that comes from is that you need to avoid potentially lots of rights through misunderstanding the differences, and indeed getting caught out by procedures. Even if you do understand the procedures, sometimes one can fall foul of those just because of a lack of experience in those areas in Europe when you're used to using the US procedures. And finally, there's a heavy opportunity to misunderstand what your European patent attorney is talking about, because some of the terms he will use will be slightly different to those you'd expect if you're working before or with the USPTO. So I hope that both the EPO and the USPTO will forgive me using their symbols in my slide set. Right, today's goals are pretty much as they were last time round, to give you the context that you need to know. Here, what you need to know is beyond the day-to-day practice. And a particular emphasis today is on the jargon that we use around some of the less common practices in Europe, and hopefully to explain that to a US audience so that it makes sense why we use those terms. Fundamentally, though, the reason that you hopefully are all listening is that you're looking for an easier life. You're looking to smooth your client engagement so that we don't have situations where your EPA, that's a European patent attorney, where he asks you for a thing, you think you provided him with the thing, he says actually it isn't, but you've already engaged with the client, got him to sign something, and then returned only to find that the client needs to do something again. Don't like that situation, so it's better to understand how the formalities work and what it is that the EPA is really asking for when they use these terms. It may not even be the EPA, it may be some of his formalities staff, his paralegals asking for those same materials. Obviously, the other topics I wanted to cover in the webinar are post-grant practice, because that is an area where a lot of questions come, because it's less frequent, but it has quite a lot of impact when it does take place. So that has to do with the procedures around disputes, potentially. And finally, just a couple of slides just to remind those patent practitioners who have exposure to this that the EPO approach to priority claiming can be somewhat different to what you're used to in the US. And that may have knock-on effects onto what you need to do early on in dealing with cases where EPO might be an option for your client. And finally, I will tie up discussing future matters, which will obviously give you more context And I know there have been questions in the past about topics such as Brexit, and I'm quite happy to put a slide or two and discuss that. So, recap. The landscape in Europe is somewhat different to the US. You do not have a unitary patent office that covers your entire process from filing a patent application to grant and enforcement. What you have in the European realm is a transnational body, the EPO, having member states, and if you'll remember from my last webinar, there was a big slide showing virtually all of the European nations are member states. Then they extend beyond those states that are members of the EU, the European Union, and that includes countries such as Switzerland, Norway, and indeed the UK, now that we have Brexit, or partially Brexit. The EPO does provide for a process that takes you right up to grant, and also to some specific services beyond grant. And I named those because I'm going to touch on them later. So post opposition and indeed post-grant amendment of other types. What I would emphasize is that the EPO does not have jurisdiction over disputes, except for those limited jurisdictions that are provided in opposition. Particularly if one party wishes to enforce their patent for infringement against another, or indeed to seek revocation of another party's patent which is blocking them, the route to doing that will generally be through the national patent offices. These national patent offices in, say, the UK or Germany or France will grant national patents of their own, but they will also hear revocation actions for national and for European granted patents in their countries. So one can imagine a situation where one wants to have revocation of a patent which covers Germany, France, and the UK, and if one is outside of the limited period for opposition, revocation can only be sought individually in various national offices for the individual national parts of that European patent. So bear that in mind when we go back to talking about opposition. Finally, national courts will handle all sorts of disputes, both enforcement and invalidity, but also the related disputes that might be there. More rarefied ones, such as whether something is standard, essential or not, can be sought in, say, the UK office. So UK courts, rather, not just in the patent offices. Just to remind you that in the process of prosecuting a European patent, it is necessary to designate the states. Luckily now you designate all of the states in one go with a single fee, and you request grant simply by paying an examination fee. These fees together can be paid up to 6 months after publication. And indeed, if you choose not to go ahead with, in that case, one can get at least the examination fee back if you don't request it soon enough. Likewise, there are some states that are not designated states, but there are states that you extend to. And if you'll recall from last webinar, then those states essentially have to be designated upon filing, but you can still pay the fees later on. So these are states that are treated slightly differently by the European Patent Office, but generally speaking, all of the states, the larger European states, will be designated states. There are a few outstanding extension states that might be of interest to some clients. So I'm simply reminding you about the designation because that emphasizes that the European patent application sits together as a single application in a single language, but it's going to split ultimately, if you allow it, into granted patents in each individual nation, which then need to be treated individually. Before you can get there, though, one needs to consider a number of formalities. And this is one of the areas where US practice is slightly different. So what I've done is, this is kind of almost a mixed bag of issues that have arisen potentially in the last 5 years or so on my list, where I have either been asked to advise by a US associate or have advised them anyway, whether I've been asked to or not. Particularly areas where it helps to know this sooner rather than later. One question is often asked is whether I need to get authorized so I can take over a client, take over work for a particular client. And in fact, the EPO is quite lax on this point. I shouldn't say lax, should we say they're easy in the sense that they do not require authorization to act on behalf of a client, but they may request it, and you can then get your client to provide the authorization. So I don't need a patent attorney straight up. It's taking the trust that the European patent attorney asking for a particular thing on behalf of a particular client and that authorization. So it's more up to you whether you wish to make sure you have the authorization in place. One exception to that would be in all proceedings, particularly all proceedings at opposition, where the division does want to know that you have the right to essentially represent that client. Authorization can be sought directly from the client or indeed from a currently authorized party who themselves has the right to sub-authorize, and that can be present or not present in any authorization. So there's forms that can be done for that, but this is a little bit different from the US. Similar to the US, we EPAs, that's European Patent Attorneys, are privileged in the sense that our communications with our clients are indeed privileged. And indeed, if I request a searcher to perform searching for me related to the European patent application that I'm prosecuting, then that will indeed be granted privilege. Privilege is differently applied, obviously, in the different national courts, and indeed oftentimes the material that we have in discussion, where I'm advising my client about fact, then we would not necessarily withhold the request. If someone says, "Could you waive your privilege?" we would potentially consider waiving it without feeling any compunction. Particularly it's at the higher strategic level, however, it's worthwhile emphasizing that communications potentially between an EPA and a US patent attorney will be privileged as regards the European prosecution. And obviously that could mean that some of the strategic discussions between the US patent attorney and his opposite number in Europe might have tentacles that reach out across the whole patent family rather than the EPA. So there's definitely a grey area, and I'm not quite sure how resolved it is in US courts. I believe that our privilege is recognised to some extent by some courts. However, district courts may have different ideas about what degree of privilege should be extended to communications with an EPA. So generally speaking, if I'm talking about any case where there's an associated US prosecution, and I think that my discussion of a European patent might also impinge, I try to make sure I'm also talking to the US attorney so that I'm covered by their privilege. But definitely one to watch. Potentially these are areas where everybody gets exposed to the vagaries of the European system, but in the European office there is a concept of deemed notification of documents that have been sent through registered letters. So I've added that a very quick note here just about postal services. You are deemed, if you have received a letter, then pretty much every letter that says in the bottom left hand corner of an EPO form that says registered letter, if it says that and it sets a date for response, that letter is deemed to have been notified to you 10 days after the date on the letter, if it carries a date. There's one rare exception which does come up from time to time, where the deadline is calculated by the law rather than by the letter, by being set by the letter. Where it's set by the law, that trumps the letter. But if the letter has registered letter written in the bottom left-hand corner, then its deemed receipt is 10 days after that. You calculate the 10 days, then you add on the time, say the 3 months, 2 months that have been sent by the letter, and then you want to do you have the date by which a response, for example, has been timely filed, or can be timely filed. Now, obviously, another area which I didn't touch in my last webinar was some of the, should we say, error fixing procedures, and one that will come up more often than not with a case where one has, should we say, a recalcitrant client who doesn't instruct in sufficient time, is that one might have to use a process called further processing. So when you see your European patent attorney talking about further processing, that is a sort of specific jargon term. It's not, they're not saying keeping on going with the prosecution. They are simply saying, they're saying that we're going to access a particular process. This allows us to essentially have an extra 2 months built onto normally a notification that a right has been withdrawn or lost. And that further processing letter will say something along the lines of, a right has been lost, you have 2 months from this date of notification, remember, to fix this. Ultimately, and in practical terms, that means one has around about 3 months to seek and use the further processing mechanism to fix a problem, quite often a problem of omission. And the reason that your patent attorney in Europe will use further processing sparsely is because it's a last chance. The case is effectively dead unless you do all of the things that have been omitted. So your EPA is slightly worried that he might not do all of those things, or the things, his response, for example, might not actually be considered to be all of the omitted acts being addressed. It's one chance. And there is a fee associated with further processing. It can be quite a major fee. So your EPA will also be trying to get to a point where he can minimize at least some of the further processing fee. Where the omitted act includes payment of a large fee, such as the examination fee, that can be a further processing surcharge of 50% of the unpaid fee. So that can be 1,000 or more euro, which he may or may not want to avoid. Another procedure which you'll hopefully never see using the European system is restitution. And the idea here is a complete foul-up has happened between paralegals, formalities, data entry clerks, whoever, and somehow all reminders have been missed. But having discovered that the mistake has happened, one can seek to restitute the case, bring it back into prosecution, pending state, as if it had never been out of that state. So it's different from further processing, and the conditions are much more stringent. So restitution is something that one sees. I've seen it on one occasion where an inventor applicant died, for example. This happens, and the successors entitled just did not get around to doing the things that were asked of them in time. Restitution was sought and was allowed in those circumstances. So those formalities that hopefully questions come up around these quite regularly. Even more regularly, one has a client who wishes to transfer their rights from, or they have effectively had an assignment, or there's been a merger, and they wish to make changes that need to be recorded at at the register of the EPO. First, why would you want to do that at the EPO? The very strong reason for doing everything you can at the EPO is that it can be done once and it covers the entirety of the patent's possible scope. So that rather than having to seek to record a transfer in each of the individual national offices, one centrally records one assignment once for a very reasonable fee. In fact, your patent attorney will probably be charging you significantly more in their time than the official fee, even for relatively simple cases. There are differences in the way that assignment and recordal of assignment is effected in Europe, and I want to just simply emphasize these differences here over those in the States. Firstly, in the States, assignment documents are used to assign from the inventor to an assignee. In general, in Europe, that is not going to be necessary. One doesn't need that because the inventorship declaration form simply says one needs to state the name and the address of the inventor and the date that the assignment has taken place, if there has been an assignment. In the European realm, domain, one can assume that the employee invention belongs to the employer. Now, that can obviously get quite complicated when one is not quite sure who the employer is, but in the vast majority of cases, if you file an application in the name of an applicant, there will be inventors, and those inventors are assumed to be employers or employees, or indeed to have assigned to the applicant. And the EPO doesn't need to see an assignment document from the inventor to prove it. Where an assignment has taken place, say between one party, one firm and another, then the assignment document needs to be quite significantly different from what you have in the States. It needs to be both handwritten in terms of the signature. It needs to identify the name of the person who's signing it on behalf of both the assignor and on the assignee. We need both signatures to be there present. Obviously the signature needs to be dated, and the person who's signing it needs to show what their position is so that we know that they are authorized to sign on behalf of the assignor or the assignee. So quite often you'll see that the forms will have, that the EPA will present to you will have a space for a date, a space for a position or a title, and title on its own has to be something quite specific and concrete. Simply entering director, for example, might not be enough. I've had that challenge more than once. The stricture on handwritten signature means that in many times, even a DocuSign type electronic signature will not be accepted, despite it looking like a physical signature. It might even be a physical signature which has been scanned and used as a proxy for the normal handwriting signature, might be rejected by the EPO. They're quite old-fashioned, and basically this comes down from the fact that we're dealing with 27, 28 different countries with slightly different laws about what is required for an effective legal assignment to be placed. So we're talking about essentially not lowest common denominator, but lowest common denominator, but all denominators. One has to achieve all of the things that all of the different countries would accept to have the minimum, so that they can accept this as an assignment. The assignment document itself, we'll maybe come back to this a little bit later, should, in its best form, assign rights, potentially rights that you don't have or wouldn't specifically have in US law. And I'm emphasizing the right to claim priority because I'll come back to that. In US law, as I understand it, there is no specific right to claim priority, whereas that is recognized as a separate item in EP law. So as I've listed there, it's best to transfer all the rights in the application, including the right in the invention, in the application, and the right to claim priority, but also rights of the patent when granted, and divisionals, even to enforce the patents or the claim to past damages. So I mentioned priority, and priority I'm going to deal with separately rather than as one of these items here. But in association with priority, I'll just simply note that in terms of documents, the priority documents, a recent query came to me saying, could we get hold of the European patent document, which had been the priority document for what has subsequently become a US patent application. Now, had it been the other way around, the filing receipt for US filing would give you the access code, and the EPO could tap in the access code and they would have access to the US document. That's because their way of using the bilateral agreement between the USPTO and EPO. It doesn't work quite the same way, the opposite direction. More needs to be done, and in the case that I was looking at, in fact, what should have been done wasn't done. Was that the PCT system was indeed used because the USPTO should have received a copy of the priority document through the International Bureau, because a PCT application was filed claiming priority from the European, but it didn't happen. So in that case, one needs to actually request specifically a copy of that document, despite it being available on the European Patent Office register. It's worth bearing in mind, if you know that and particularly if you're going in the direction of European as priority and US or international application as subsequent application, then it may be necessary to get hold of the European document. And you might not be able to do it in all cases without going directly to the European Patent Office and requesting it. So, watch this space there. Okay, in terms of language, multiple countries around Europe, multiple languages spoken there. You will be fully aware that the language of prosecution of European applications is one of three: English, German, and French, which covers many of the second languages, if not first languages, of the countries involved. In terms of percentages of different applications, English makes up about 80% of those applications, German about 15 or 10%, and French the rest. However, you may have an applicant who is actually resident in a country other than one of those where English, German, or French is the official language. So I've mentioned Spain and Italy because those are the major examples. And if that is the case, then consider not recording that assignment from one applicant to another. And for example, from the Spanish group member to the group corporate company based in, say, Germany. Until you've actually paid your fees, because you can get a fee reduction for certain of the fees, and that can be amount to about 20% off certain fees. That's supposedly to make up for the fact that language translation will be necessary more often than not for that applicant. But it may be something that a client might want to take account of. Do ask your EPA if that's something you're thinking about. I've mentioned presentation of both claims and description here because there too there are differences between US and EPO practice. Now, there was a topic in my last webinar, but I just wanted to emphasize again that the form of the claims that we use in Europe is essentially similar to yours. We tend to have a pressure to reduce the number of claims to 15, simply because there's an excess claims fee which is quite considerable beyond the 15th claim. And likewise, in terms of the description, there are differences in terms of what we like to see in Europe and what we don't see in Europe. Generally speaking, the distinctions are things that your EPA will be able to amend for you. But and I think it's almost a topic for an entirely new webinar, is how one drafts so that one can use a specification for both European and US practice without having to make any major changes between either one or the other, essentially trying to find common ground between the two. and it is possible to have it with common ground. But don't be too surprised if you instruct straightforward filing as far as you're concerned and find that the EPO requirements mean that your poor EP opposite number is making changes to your claim set without your particularly asking for it. They're essentially what they're trying to do is trying to make use of multiple dependencies where that might not be feasible in the States, or indeed to insert reference signs where that might be done. So don't be too surprised, just the same way as we expect you guys to take a set of claims that we send you and make preliminary amendments to it to make it look correct. I have, for example, received a US examination report where the first two rejections were that I'd used non-standard English, only to find out that I'd spelled colour with an extra U. How dare I? Now, finally, one of the things I really wanted to talk about was to make sure that at the end of the day, we have strategic ideas about what we're going to do for our client. We don't just file the patent application because we like to get the things granted. We file them because they're going to be a useful tool for our client. Now, there are other things we can do for our clients, including filing third-party observations. Now, the EPO has a slightly different way of doing everything, and in terms of third-party observations, this is one of the areas where it is so informal. It can be pretty much any form one likes. One has to say who's filing the observations, but one can use a straw man to make those observations. Third-party observations, I find, are not always perfect because because essentially it's too early. It gives the person who's trying to prosecute a patent too much notice of what it is that you're doing. It tells them that somebody's interested in the prosecution, so that potentially their patent might block somebody else from doing something they want to do. And it can also lead to an improved third-party patent where it has been challenged with greater vigor than maybe the examiner on its own might have done. So in general, third-party observations remain something that, while possible and relatively easy thing to do, something one might not do. Again, I would take advice before filing third-party observations, but notice that one can do it. A more usual situation would be to engage with the Patent Office through some other route. If one really wants to knock out a patent, opposition is the way to go. Before I discuss opposition, though, we need to discuss another area, a larger area, which seems to cause more confusion to my opposite numbers than many other things, and that's how one deals with the situation similar to the situation that arises when one has a final office action in US prosecution. Essentially, the prosecution is ground to a halt. Amendments are being made. One party, say your attorney, is simply rebutting what the examiner has said, and the examiner is rebutting what the attorney is saying. At this point in the European view, the best thing to do is to give you the right to be heard, and their best way of doing that is to allow for a procedure called oral proceedings. You'll see every single letter in response to the EPO that an EPA will file will have at the end of it a request for this, and this is essentially a procedure which allows the tying up of all the loose ends, a final decision to be reached. It starts with a summons. Attached to the summons simply says a date and a time and a place, and attached to that will be an annex which effectively will repeat a assuming that we're at a standstill, will repeat all of the objections that have previously been made and that haven't yet been addressed as far as the examiner is concerned. He won't simply summon you on his own. He will go to a couple of his colleagues, normally a senior colleague, and potentially one other, and they will all three of them, as the examining division, come to you and say, okay, well, what the primary examiner, the prosecuting examiner, has been saying is correct. We need to hear your side of the story now. So all proceedings are set up as a hearing in person, but can be taken via video conference. They're also a formal procedure, and they're not public when they're before the examining division. And this would be your final stage of examination of the case. We don't have a procedure such as the RCE procedure, when we're going to restart for a fee. Bear in mind that sometimes it's wiser to restart a procedure using the divisional process in the filing of a new application. But sticking to the one case of all proceedings, one would respond to the summons with at least one set of written submissions. Typically that written submissions is just like a normal response, but attached to it will be not just one set of claims, but potentially more than one. We call them requests. So I've put inverted commas written submissions, I've put inverted commas requests. These are terms of art that we use, the jargon terms that we use to refer to these processes. So that's why they're generally capitalized. I typically file a main request, which almost inevitably mirrors what we have currently got on the file, because we want to have the broadest possible scope in any set of claims that we can appeal. There's a time limit set for filing the written submissions, which is normally a month before the OP takes place, but you can still make submissions after that, generally speaking, arguments rather than new sets of requests. And then again, you've got a choice. If you're lucky, the examiners will have another meeting in advance. They will look at all of the submissions you've made so far, and they'll write to you with their preliminary opinion. And that might or might not make your decision for you. You might decide, actually, OP cannot go ahead, we're going to lose, what's the point? Or indeed, we can make and we can actually ask a request that we don't have the oral proceedings, which we request to withdraw all of our requests. And the board will simply grant that request, and they will issue a decision on the state of the file. If the oral proceedings does go ahead, all of those requests are considered in order, and then a decision again is reached. That it will either be the application is refused or the application is allowed, and that decision, either way, but normally refused, is appealable. If there's any luck, you'll get grant. You'll have a decision to grant, a decision to allow, and in that case you'd have an allowable request at the oral proceedings. And that will turn into a set of allowable text, which is sent to you in a communication under Rule 71.3, and it is that you will see in the normal prosecution of the case, where proceedings don't take place, as well, where the latest version of the claims from the last response appear attached to the Rule 71 communication. Now, a lot of this is familiar stuff in terms of the grant procedure, but it's worth noticing that one has time after one has paid the fees, translations of those claims. It's possible then to say, okay, which countries do I actually wish to carry on in? Which of the European countries, the member states of the EPC, do I actually want to have a patent in? And this is validation. So this is the term that we use for those. And obviously, formality staff will be more familiar with that than I am. Opposition, I mentioned. Even after grant, it is possible within a certain set period of 9 months from the grant of the patent to seek the revocation of any European patent. And as far as I'm concerned, that's the closest thing to a post-grant review that you'd have in Europe. We have specific grounds of opposition. They're more limited than they might be in the States. You can oppose on the grounds that the claimed subject matter is not new, inventive, or patentable, that it's insufficient, or indeed that the subject matter extends beyond the content of the application as filed. We call that added subject matter. It proceeds in much the same way as all proceedings did before the examining division, but in this case it's inter partes, so there are two parties. There's an opponent and a proprietor, and it is a public proceedings. So generally speaking, all proceedings by video conference for opposition doesn't happen because of the public nature of the thing. The opponent sits on one side, the proprietor sits on the other side, and they both face the opposition division. Again, 3 examiners who will ask pointed questions and try and chair a meeting between the two of them. There's a written process before the opposition actually takes place. The hearing takes place, where you start with submissions being made by both parties. They can cross over one another, but eventually what happens is that one party submits something and another party submits a response to that. That means that if one is the opponent, one can react to arguments and potentially other requests that are being made by the proprietor, as the proprietor attempts to shoehorn their invention into something they think is patentable. The prior art should be filed with the opposition, but it's possible to file it later, and it will be considered basically on discretion of the opposition division. In opposition, slightly differently to the procedure for the examining division, the opposition division will deliver an interlocutory opinion. It's only nice to have in the examining division. That interlocutory opinion does give both parties the opportunity to kind of really go into how likely is it they're going to win, and gives an opportunity to work out how to manage the case. So which arguments to run, which not. Because bear in mind, one has a limited amount of time to run the proceedings. This is not a full court case, and though if something extends beyond 1 day, it's very unusual. On the day that's set for the oral proceedings, one has normally a number of arguments to run. The way the examiners run the system is that they allow both parties to explain their case. Normally, they don't want straightforward reading off of earlier written submissions. They're wanting a fresh case to be presented. And the idea there would be so that nobody's wasting anybody's time. So assuming case management has happened, both sides have agreed that effectively certain things won't be run. One can reach a conclusion, again, a decision at the end of the day. The decisions at the end of the day for oppositions can be one of 3 things. It can be revoke, it can be keep in force as it is, and then there can be a sort of partial revocation of the case. So certain claims, for example, can be allowed and certain not, or an amendment can be made. And there's different treatments of all of them. In each case, the decision can be appealed. So if an opponent wins, then quite often the proprietor may appeal. Likewise, the opponent may lose and may appeal themselves. Appeal can also be sought from the decision of other divisions of the EPO, so particularly the examining division, but the legal division too, and indeed the formalities division in certain cases. And I've set out these things because the important thing about appeal is that there's a limited amount of time in which one can appeal. And I'll just mention the notice of appeal deadline, which is a 2-month deadline. And that deadline is important because even if no appeal is going to be filed, the state of the EPO now is that one can still file a divisional application up until that 2 months that notification of the decision has elapsed. So while in principle one could have appealed, it would be possible to file a divisional application. So that's the latest one can file a divisional application in the European prosecution. But please, 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 as a European patent attorney, I beg you, don't tell me that late. Do tell me much earlier if you want to file a divisional application. We'll be asking well before then, in any case. There's a last note to be said here, where that last line we say the appeal proceedings can become a re-examination process. The appeal board, the technical board of the EPO, try their damnedest to stop it being a re-examination process. So while it can become a re-examination process, that's something they push against. They see it as a quasi-judicial process. They are not retrying the case. They are simply looking at whether the particular decisions that has been come to reject a particular request was correct in law or not. So we need to point to errors in law if we're going to succeed in the appeal. There's no court to appeal from the Technical Board of Appeal, so it's very different in that respect from the US system. There is a thing called the enlarged board, but they only hear points of law that don't refer to it when decisions diverge. So one has technical boards in different areas, and they might make an opinion on a particular interpretation of the law, and it may diverge. And they're becoming rarer and rarer, but there are certain decisions that are being considered. So your European attorney will tell you if there's a case for one or other of these things to take place. I've mentioned the normal way that post-grant amendment happens, as in the result of an opposition decision to partially revoke, but it's entirely possible for the proprietor themselves to seek to limit or indeed to revoke their own patent. And here, slightly differently from the opposition procedure, there's no restriction on the period between the grant of the patent and the filing request in which one does this. And when one requests, say, to limit a patent, it is only to be examined for compliance with the clarity and the added subject matter provisions of the EPO, not others. So that, for example, non-unity objections will not be raised. Right, we're on to the final stretch here. I just want to take with a couple of slides to remind that the priority system in Europe is interpreted slightly differently, partly because we have a slightly different prosecution structure. So we've got the opportunity to claim priority and to correct that within 16 months of the earliest claim priority date. That means that sometimes when somebody says that there is a priority document, but I just don't know what its details are yet, quite often your EPA will actually file it deliberately making a mistake in the priority date, so that it can be a deliberate error that can be corrected. There is no requirement that the correction should be obvious. It simply needs to be correctable. So and generally speaking, one makes a corker of an error rather than a very slight error, just so that it can be detected by the formalities examiners. I've simply noted here that priority can only be claimed from the first application anywhere in the world for the invention, so that when we discuss a continuation or a continuation in part, it can be the first disclosure can be in one of those documents, but only that part of the document that makes the disclosure is the source of the priority claim, if one follows me. So some of the other material in those documents can have earlier filed material in them. That will have no bearing at all on any priority claim to just the CIP. So do bear that in mind. It's slightly different to the States. I've emphasized that the right to priority for claims is based on the whole disclosure, not just on the claim. So it doesn't matter that you don't have a claim there, as long as it's described somewhere in the description. But the description must be sufficient for the claim to be valid. So there must be directly and unambiguously derivable. That's a quotation from one of those rare enlarged board decisions, G2 of 98. And when one files a priority application, it needs to be a full specification. I put a very brief problem there, but that illustrates some of the difference between our interpretation in Europe and that in the States. I won't discuss that in detail because I want to carry on and to discuss a couple more items. To emphasize, again, this is one of the higher strategic points, that enforcement in Europe is different, very different from the States. Disputes are handled by national courts, and they only have authority in their own jurisdiction. There are some exceptions in extra national jurisdiction. There are specialist patent courts, for example, the patents courts in the UK, but in general, there are no jury trials of patent cases anywhere in Europe. Germany doesn't even have discovery, whereas you have something that you would consider quite limited in terms of discovery in the US, in the UK. And in German courts, while one cannot have experts at all in the court may appoint an expert with the agreement of both parties. I mentioned Germany quite a lot because Germany has another, should we say, a quirk to their law in that the infringement and the validity of the case can be tried separately in bifurcation. And indeed, in the UK, that would not be the case. All of the matters, infringement and validity, would be tried together by a court. Now, I'm aware I'm running short of time, which I didn't expect. There are other issues that one might notice where there's difference between the European and US approaches, but they tend to be slightly, there's slight differences. And probably expected ones. So there are provisions against double patenting in various European countries, but that is changing. So it may be the case that post-Brexit, the UK introduces some different rules on double patenting to those presently. Watch this space. I've mentioned languages, but I haven't mentioned SI units. The expectation in European realm is that the SI units are used throughout, unless there's a very good reason not to. From a consumer electronics point of view, I will describe the size of a monitor in terms of inches, but I will describe a ferriole in terms of millimeters. I won't talk about pressure in terms of pounds per square inch, for example. I will choose to use the SI unit expression instead. And we will be asked to replace or to supplement any non-SI units with SI units, if at all possible. I mentioned the PCT route there because that's something that can be a very useful thing in terms of Europe, because if one remembers the difficulties one might have in recording an assignment in the European Patent Office, one can avoid most of that by sorting out assignments while still in the international phase. And I would emphasize anybody who has an assignment and they're dealing with a PCT application that might go to EP, do it while it's in the international phase, because one can have an assignment that's only been signed by one party, the assignor, and indeed can use electronic signatures. Both things can be very inconvenient if they're not done at the right time. I very briefly mentioned UK protection, and my little reminder, if anybody who's still listening who remembers the first slide where I had a picture of Hong Kong Fui on the screen there being confused, Hong Kong is another area where the existence of the connection between EPO to the UK and then from the UK to Hong Kong means that re-registration of a standard patent application can take place, provided there is an EP UK or indeed a UK national application. Something one it doesn't always think about, but it does appear on everybody's reminder list. It's a pain. Interestingly, I found out that Hong Kong has now started accepting direct registration of standard patent applications, but that's for another webinar. I mentioned PPH, but only briefly to dismiss it and say that PPH, while in principle is a wonderful thing, the patent prosecution highway should allow an allowed US patent to turn into an allowed European patent. The EPO takes a slightly different view. They look at the differences in law, and essentially examiners more often than not reject the use of PPH. Quite often I'm told to use PPH just a little bit too late because it's only useful before examination has begun. Finally, some more fun slides. Brexit. I have been asked specifically to talk about Brexit, just simply to emphasise that the EPC, the convention upon which the EPO is bound, is not the EU, so that while the UK is currently out of the EU, we're in a transition period which lasts until the end of this year, which we don't expect to be extended. But the European patent with the UK and indeed a GB national will stay just exactly as they are. And indeed, the major area that anyone thinking about Brexit should consider is more of the provisions in licenses, where they might refer to the EU without being specifically including the UK, because obviously that's changed. I would also emphasise that there are 2,500 odd European patent attorneys active in the UK, according to the EPO site, of a total of almost 13,000 EPAs listed there. But they are fully entitled to represent their clients in proceedings before the EPO, and they don't need a work permit, which is really very reassuring. We don't have any guarantee that's the case, but it's good to know. Finally, you may have heard of the UPC, or the Unitary Patent. This is almost the unicorn of the European patents field. We would like to have a true European patent with a system of central and local courts to handle disputes at a UP court. The UK participation seems to be in doubt to some extent, because the ultimate appeal from those courts was going to be the EC, the Europeans' own court. But there's been some murmurs from our government saying that they might want to participate anyway, if it can be done. However, all that said, there is no expectation that we're going to have a unitary patent in place before the end of the Brexit transition period, which is very sad. So hopefully everybody is still vaguely awake and might want to ask some questions. I've not looked to see what questions we've got. I'm basically coming to the end of my process, but hopefully this has not gone faster than the human eye, and there are points for anybody who can tell me what that's a reference to. Thanks for listening. Do we have any questions? I can see one question actually in the chat, where someone's very kindly pointed out that examiners should not object to the specification because British English spelling has been used. I wish I had known about this at the time. Thank you. That's David Schifrin. Okay, so I have a question here from Erica Poole, asking about the frequency that OPs happen. So let's say the examination process, essentially it's down to your client. I have had, should we say, Far Eastern clients who refuse to take no for an answer. In those circumstances where face needs to be saved, it needs to be done. One can imagine, I think I had maybe 10% of my cases or proceedings were at least scheduled, and it was always the challenge to make sure that the client understood that they were not going to win, and then to see whether one can actually get them something anyway. So 10% would be for the kind of typical electronics, consumer electronics client, where you haven't managed to sort it out previously. But effectively, it's how long is a piece of string case. It's if you have a client who sees the first set of search results, really looks through them, decides that actually that is prior art that is going to be a problem and then gives up, then that client will never see an OP. In terms of the kind of the alternative situation where one's talking about oppositions, and OPs happen every time an opposition is scheduled, and even if one tries to settle sometimes, the oral proceedings may proceed anyway because the examiners may think that they've got a better reason to reject the application than the opponents have given. The follow-up question that Eric has put is about the success rate. Generally speaking, it's a bit like talking about court cases. Generally speaking, the reason that you're there is because it's up in the air. If you're going to win, then as the proprietor say, then the examiners are quite happy to grant you the patent, so you win. And generally speaking, that's going to be the case. I mean, I would say 50% of my cases, it would have been a case I've taken from somebody else. I've seen an argument that I've been able to run, and the examiner said, okay, well, if I screw my ears up, I can see that too. It tends to be the success rate is greater when either you are new representation on the case, so you've got fresh eyes, or indeed that there's a fresh examiner at the other side, or indeed he's talked to his principal examiner, the principal examiner disagrees with him. So I would hope that I have at least a 50% success rate, but it can be much, much lower. And if you've got a client who just fights every single battle and loses every single one because they just won't accept that the EPO is different from the US, or more likely they're different from the Korean or the Japanese patent office, then it can be a very low rate indeed. I don't know the across the board rate because again, one doesn't know how many cases are settled and that the examiners don't proceed with. So hopefully that's answered a number of questions for people there. Thank you very much indeed for spending the time with me today.